Now, our next session is on mass arbitrations, and Professor Fitzpatrick gave us a teaser this morning on the topic. So it's my pleasure now to introduce Matt Dundon, principal at Dundon Advisers, who will moderate this discussion.
Hi.
Matt?
Thanks, Chris. And I welcome everybody. Thank you for joining us virtually. Mass arbitrations and the class waivers to which they relate are one of the more interesting issues in civil litigation going on right now. They're widely publicized, and our firm, which has a business in the secondary market in litigation investing, as well as a variety of interests in class action and other forms of representative litigation, particularly against bankrupt companies, we thought this was a really interesting panel that we might sponsor and bring to you. So we're joined with a great and diverse group of folks today. If you have the gallery view on the upper left-hand corner, is the Honorable Shira Scheinlin, retired district judge and of counsel at the Strook firm. To my right, or stage right, is Josh Konecky, partner in the Schneider, Wallace, Konecky firm out in California, leading plaintiff lawyer with significant experience in this area. Down on the center left is Travis Lankner, a partner in a Chicago plaintiff law firm that's made a big splash in this area, particularly with mass arbitrations, and a distinguished background both on the legal and the financial side of litigation. We've got in the very dead center, standing up, very good, Ray Gallo. Ray's also a West Coast plaintiff lawyer, but has lately become very involved in the technology and business side of originating these claims. We are also supposed to be joined by a colleague, a partner at, or an associate at K&L Gates, who will also kind of add some substance on the defense side. I don't yet see him on the screen. Actually, do we have him? I'm not sure if we have two screens here. Hold on.
What's his name?
Sorry, we have, just one second, see if we've got him up here. So it's Wes Pritchard. Wes, do we have you? Don't think we have Wes yet. Okay, so with that, just at the highlights, we're going to talk.
He did write, I'm in the meeting, but it does not have me as a panelist. We just got a chat.
Okay, we now have him here. We have got Wes here, great. So Wes is a litigator at K&L Gates and will also be speaking to us from the perspective of the defense bar. So we're sort of thinking about this in three basic divisions, and hopefully we'll manage our time appropriately. The first is, how did mass arbitrations come about? What has been the impetus in law and business for their people to be doing this? Secondly, how are they happening now? What are some of the interesting issues that are being disputed and developing? And how are they being done at a technological level? And then third is kind of to look forward a bit and think about changes both on policy level and on the practical level that may occur to change the tempo of how this is being dealt with, or maybe even change the substance. So with that, in terms of the backdrop for how these mass arbitrations came about, I think I might throw it to Josh and Travis, maybe Josh first and then Travis pick up it as appropriate, to sort of talk about the setting of consumer and employment class waivers and arbitration agreements, and how mass arbitration came to appear as a possible solution from your perspective.
Sure. Well, thank you all for having me. And as Matt said, we're a plaintiff side class action firm. And we do a lot of different cases, but my main practice is in employment, class actions, a lot of wage and hour cases. And our foray into this area really just started as a response to more and more of the our cases, after being filed as class actions, being met with these forced arbitration agreements with the class action waivers. And so what we have been doing, I mean, generally speaking, we still believe that having class actions is more efficient for all the reasons that the class action device was started so many years ago, so that we could all be in one proceeding and be more manageable. But as the arbitrations agreement came out, started becoming more prevalent in the class action waivers, we've really started from the get-go in our outreach to prospective class members and others to have more people retained in the class up front, to, if they are interested, to move forward in individual arbitrations or many individual arbitrations together in the event that a class action can't be maintained in court. And so that's really what our practice has evolved into. I mean, we still do quite a bit of class actions, but the process of being prepared to do both is something that we've had to do. My limit, and this may be a subject for a little bit later on, but my experience so far in doing these mass arbitrations, and I come at this from a employee advocate's point of view in terms of trying to use resources somewhat efficiently, is that what ends up happening, at least in the cases I've been involved with, is that with the arbitration, the arbitration agreements, we end up spending so much time and resources and money litigating the procedures of arbitration, including who's going to pay the costs of arbitration, obviously, and other procedures. And that at the end of the day, ironically, and there's two particular cases I'm thinking of in this situation where the resolutions and the settlements that have been achieved in some ways were probably more higher amounts than they might have been had they stayed in court, because the limited, a lot of these claims could be very small claims. And for example, people working off the clock with very low wages to begin with, and having a lot of very small claims that potentially could have been resolved in a class context. But going through the whole arbitration process, the expense of the arbitration, which generally speaking does need to be borne by the defendant in the first instance if it's a forced arbitration agreement, ends up creating a lot of leverage for the plaintiffs to sort of have that recovery. So it's, in some ways, I suppose that's good from a plaintiff's point of view, but it's also, I think, somewhat inefficient. It's sort of delays getting to the heart of the matter in court or in what might be a single class action. But in any event, it has sort of provided the alternative of if forced arbitration agreements with class action waivers are what the plaintiff's bar needs to deal with, then it's just a matter of figuring out how to be in connection with the members of what would have been the class more rigorously and more actively before class certification than what people might have been doing when there was a class action or a putative class action pending in court, where a lot of the merits development might happen at a later stage. So that's sort of where we are, and I'll kind of stop there and leave it for follow-up questions or others to speak on this preliminary matter.
So Travis, could you filed a number of pretty high-profile mass arbitrations recently. Give a little bit of your perspective on how you came to perceive this as an opportunity for your firm and how it's been working for it, how you got into it.
Sure. Well, I would echo some of Josh's comments. First of all, good afternoon, and thanks to everyone for having all of us. And this has been one of the slicker and better orchestrated Zoom setups I've seen to date, and we've now seen a lot of those. So this is great, but thank you for that.
Credit to our organizers.
So this developed in response to the proliferation of class action waivers and related procedural and contractual devices that were litigated, including up to the Supreme Court level several times over the last 10 and frankly now more than 10, dozen going on 15 years. And in getting ready for today and kind of thinking about that, I pulled an old amicus brief that is an amicus brief that the Chamber of Commerce filed on the merits, at the merits stage in the Supreme Court in the Italian Colors case with American Express, which was a case in which the court ultimately held that the higher cost of arbitration, including of the antitrust claims at issue in that case, was not a sufficient reason to overturn the arbitration clause, which contained a class action waiver. And in its amicus brief, the Chamber actually approvingly described the very thing that is now occurring as a result of these waivers being in place and frustrating the ability of plaintiffs to bring class actions. And they actually used Concepcion and what happened on remand in Concepcion as the example. And in the amicus brief, the Chamber goes through and says that the district court in that case compelled the plaintiff to arbitrate after the Supreme Court issued its decision. And the plaintiff's counsel then filed separate demands for arbitration on behalf of more than 1,000 claimants, each making virtually identical allegations and relying on the same witness, whom the original plaintiff had proffered in support of his class. And the parties moved forward to arbitrate claims on a class basis. And most of that was me just directly quoting from the Chamber's brief. And the Chamber says there that this all demonstrated that, quote, especially in an era in which the internet and social media can be used effectively to reach out to potential claimants, individual plaintiffs and their counsel can readily identify other businesses or individuals with similar claims who can share in the costs of pursuing claims. So, end quote. And now my editorializing, which is that's exactly what's happening here. And the business lobby previewed it for the world in filings at the Supreme Court just about 10 years ago in the Italian Colors case. I think the reaction that we've seen in the matters that we've filed is interesting because to my mind, it reflects that many defendants and their counsel thought not only that they were getting a class action waiver, but that they would effectively get a liability waiver or all but a liability waiver as a result of inserting a class waiver into their arbitration clause. And so firms like Josh's and ours and others across the country have done our level best to make sure that that is not what occurs and that individual plaintiffs who have claims in these situations can litigate them. And I would just make one more introductory point and then happy to let it proceed from there. But I think you hear a lot and you see a lot in the objections that defendants raise in our matters about the burden that is placed on them, the various things that are required of them as a result of multiple individual arbitration demands being filed. And I would just say that those complaints usually focus on some of the early steps in the arbitration that a respondent is required to take under the governing arbitration agreement. And those complaints usually miss the bigger picture. When you eliminate the most efficient way to achieve global peace and resolve claims for a large number of people, if you then violate the rights of a large number of people in the same way, there are now firms like Josh's and ours and others that have figured out how to litigate many of these individual claims simultaneously. It's not just about the filing fees or some of the procedures. That's only the beginning. And generally speaking, firms on the defense side are not prepared or not as prepared to litigate all of these claims at once, and really are not contemplating the ramifications of having converted a class action regime where per class member settlement values are generally lower and claims rates can sometimes be quite low, not contemplating the ramifications of having replaced that regime with an individual claim regime where resolution requires getting each individual claimant to sign a release and to accept an individual settlement offer. The costs of that are very different. And so you see a lot of complaints about the procedures or complaints about boilerplate, quote unquote, arbitration demands. But of course, common issues of law and fact generally predominate in these cases. But for the class waiver, they would be class action. So some of the reason for the boilerplate is that a lot of the law is the same, and it's just reproduced for each individual plaintiff or claimant because that is the situation in which the contract puts them.
So I'd love Wes and Judge Scheinlin, please get ready to kind of come out with the defense perspective on the spirit of these agreements in just a second. But I'd like Ray to sort of finish up this first section by really getting in sort of granular into how people are finding their mass arbitration clients, how they're bringing these cases, some of the business and technology. Ray, you're on mute. Got to unmute yourself.
Thanks, Matt. I wanted to start by saying that I loved our introductory keynote. You know, I was a college Republican eons ago, and it is just what's supposed to be happening here is we're supposed to be finding efficient ways to resolve disputes and get to fair market outcomes where competitors who cheat or steal or lie don't get advantages over competitors who play fair, and consumers can spend their money or employees can spend their time in situations where they're getting what they bargained for. So, you know, the keynote was perfect in that regard. And then the question sort of becomes, in the world that Josh and Travis just described, you know, how low can we get the cost? How efficiently can we handle very large volumes of claims? Now, some of you know that I and my firm and my co-counsel have been doing mass joinder cases and then arbitration swarms since 2007. And I started building custom software in 2010 to make this as easy as possible. And it's simply true that class actions are the most efficient in a lot of ways. On the other hand, it's also true that even where you don't have an arbitration clause, forced or otherwise, and even where class certification is possible, which it isn't always in lots of righteous cases, there are situations where individual litigation is superior. And if you can drive the cost of handling those claims, if you can be efficient enough in handling those claims, you get a better, fairer result. You get a situation where you're not giving releases for people who don't get paid. You aren't putting on the common case, you're putting on the best case. The people who step forward and are willing to do a little work as witnesses for themselves get paid more than the people who are only willing to stay in the back. Several other similar issues, and one of them is, from a plaintiff's perspective, is attorney's fees. You know, Brian brought up this issue of, the truth is that fees in class cases are a fraction of what they are under private agreements. And the fees in class action cases, frankly, from my perspective as a plaintiff's lawyer, often, if you do the economics, they aren't high enough. The courts don't really get how many cases we work on and work on and work on and don't even file, or work on and work on and work on and don't get a great outcome. And never mind the inefficiencies of court approvals, et cetera, objectors. So there are huge advantages to these individual cases where you can make them efficient enough. And so, you know, leading into Matt's introduction for me, I've been working on how do I market, how do I build technology, how do I use that technology to be as efficient as possible in delivering really great client service and enabling myself to then go into court or an arbitration hearing and advocate effectively. And so, to my mind, it's two components that are, you know, inextricably intertwined, but nevertheless separate. One is, what's the technology? And as Travis pointed out from Italian Colors, you know, yes, the internet, and yes, software. But two, what's between our own two ears, right? All of us as humans, we are resistant to change. We are resistant to new ideas, doing things new ways. And as lawyers, we're trained to be even more resistant because we're trained to please don't screw up, right? I mean, I don't know how many of you are out there thinking, I would love to do this. Let me just ask you, how scary does it sound to have 1,000 new individual clients? If that makes you nervous, that's because you're smart. There are potentially a lot of problems. So how do you do that? There are, in terms of marketing, I mean, look, if you do the reading these days, everyone can see content marketing is king. I'll give you a simple example. This summer, I signed 300 plus clients with 20 million plus in claims for about $3,000 because I just put the information out there and promoted the information and let clients find me, as opposed to trying to sell clients on me, which everybody's tired of, hearing people and products marketing themselves. So from a marketing perspective, that's the short answer, and I'm happy to talk to people more about it later. From a pure technology perspective or operational perspective, as Travis is pointing out, how do we actually get this stuff done? You can buy off the shelf products cheaply. You can use Constant Contact. You can use MailChimp and SurveyMonkey and Google Forms and all this type of stuff, and it is inexpensive. But I tried that starting in 2007, and to my mind, it isn't nearly enough. So what we did is we built our own integrated system. And by the way, there are intake systems like Lexicata, which is now Clio Grow, like Captora, but none of these are fully automated systems. So as some of you know, we built our own system. It's called Leverage. You can find it at leverage.law, but not to focus on anything except what you really need. From my perspective, you need a fully integrated system, and you need to be able to ask questions and ask follow-up questions and have your clients populate your database and have your system evaluate that data in an automated way and even ask follow-up questions in an automated way. And you need a way to have the system.
Can I ask you a question? Let's drill down to dollars and cents, right? I'm sure a lot of people in the audience are interested in knowing, if someone were to say a great mass arbitration would have 2,500 initial filers, how much would a plaintiff firm be spending to obtain in marketing and technology costs and intake costs to get those 2,500 filings?
Yeah, I wish there were a simple answer to that, Matt. Figuring that out up front is part of what you do when you figure out whether you like that case or not, right? Your marketing cost on a per client basis is going to vary with how receptive the people are. Are they actually hurt, or is this kind of found money to them, like it is in some technical cases? Is it
give us some ranges? Does it, in big mass tort cases, people can spend thousands of dollars per plaintiff to obtain them, and obviously that's probably not economic in consumer and workplace cases. So where can it live in ranges?
Well, if you're doing traditional straight out marketing, I've tried to never spend more than about $35 in consumer cases. In employment cases, which tend to be more valuable, maybe you can spend 100, 150. And these are just goals from my experience. But again, I used the example this summer where I probably spent $3,000 promoting a story that then got picked up by the press, and I've got $20 million worth of claims. So, if you do it right, if you think about it, you can get it pretty cheap. And you just have to decide what it's worth to you. How much do you think those cases are worth? How much are you willing to pay for them? And then you want to be effective with your money, obviously.
Are firms like yours, or if they're approached by a plaintiff attorney with a theory, with a prospective cause of action defendant, can you give them reasonable estimates? Like, can you work with them to say, you're going to spend between X and Y, so people can calculate that once you know what it is they're going after?
Yes, and beyond that, Matt, like any marketer, every consumer products firm in the world, you just test, right? You have your estimations, you have your judgment. You can do a focus group if you want to get really clever, but mostly you just test. You run some ads, you see what you get. Or if you just believe, maybe you go in harder. Again, this content marketing approach. I spent a day or two writing an article. Now, that's whatever it is, $15,000 worth of time, but well worth it. And you can add that to my 3 and you get a different number. Sure. But the risk was low, the promotional benefits good no matter what, etc.
Okay, so let's turn the page to to Wes and Judge Scheinlin, and I think we're also moving on to the second phase, which is how are these things working out now? Let's talk about, what are your clients thinking and what are you thinking when they're served with, I guess, the first wave of these arbitration claims, and how are you responding?
I'll go ahead and start. And again, just before I begin, I want to say thanks a lot for having me, and thanks to the panel. So one thing that I think is important to do is to take a step back to question why the class action waivers exist or became popular in the first place. Because, if class actions as a procedure are the most efficient or effective way to deal with a large number of similar claims, then it sort of begs the question of why do these exist in the first place? And a little bit of the background that I think is important is that, of course, class actions are sort of a rare exception to a general rule that each person brings their own claims on their own behalf. And part of the reason that a class or collective action is an exception rather than the rule is that it can, and certainly not in all cases, but it can permit a small number of named or representative claimants to be identified that might have the best or most meritorious claims, and then have those few claims stand in place of an extremely large plaintiff base, the vast majority of whom may or may not have meritorious claims. And then, notwithstanding the merits of the majority of the claims by the claimants who are not at the forefront of the suit, defendants are faced with a really disproportionate incentive to settle a case if a class is certified. So to protect against that concern in others, Supreme Court precedent includes a number of procedural safeguards in cases such as Tyson Foods, Walmart, and Comcast that require a putative class to present evidence that its claims are sufficiently cohesive or sufficiently related. But nevertheless, you have some jurisdictions that have diluted these procedural safeguards with processes such as permitting issues classes or certifying a class without applying that rigorous evidentiary standard that was enunciated by the Supreme Court. So given that history, entities that could be putative class defendants in contractual claims began to include dispute resolution provisions in their contracts that included a collective and or class action waiver, which the Supreme Court then upheld in Conception. And so following the Supreme Court's decisions in Conception and Epic Systems, there have been these mass arbitrations that have been filed that, generally speaking, involve arbitration agreements whereby the respondent agrees to pay the vast majority of the filing fee. And so you have cases where, for example, there could be 10,000 individual arbitrations filed, all concerning the same or similar subject matter, and all using essentially the same arbitration demand that would force the claimants to collectively pay, say, $1 million in arbitration initiation fees, but then requires the respondent to collectively pay $15 million or so, just for example. And that's just to get the action initiated, sort of as the upfront cost. And so I think that a major issue from the defense perspective is that in practice, these mass arbitrations can sort of be an end around the class action or collective action waiver. And it comes with many of the same issues that the class action and collective action waiver seeks to avoid. For example, having to pay upwards of $10 million just to get a case initiated is similar to the proverbial gun to the head with a disproportionate settlement incentive that defendants face when a class is certified. And in an example with 10,000 claimants, it would take more than a decade to individually arbitrate each claim, even when doing 2 per day, 365 days a year. So it may not be practical to undergo individual arbitration for each of those claimants, which then imposes an incentive to undergo the very collective action procedures that the arbitration agreement bargained away in the first instance. And that gets into sort of the spirit of these arbitration agreements, where you have the Supreme Court recognizing in conception that mass arbitration would be a fundamental change to the traditional arbitration process that sacrifices informality, which is sort of the principal advantage of arbitration, and it makes the process slower, more costly, and more likely to generate procedural morass rather than a final judgment. And moreover, as I just mentioned, that mass arbitrations then invite some of the same concerns that the class action waiver was drafted to address, such as large filing fees serving as a strong settlement incentive, and the allure, can't talk today, and the allure of collective action procedures to deal with a large number of cases.
So Wes, I'd love to have Judge Scheinlin give some perspective on this, and then Wes, come right back to you to talk about mechanically what you're doing and what your clients are doing when they're hit with these things. So Judge Scheinlin?
Thank you. So I'm going to start with correcting two pronunciations. I'm Schendlin, Judy, Judge Judy is Scheinlin, I'm Schendlin. Secondly, concepcion is concepcion. It is not conception. That's a different process. We don't want to talk about conception today, but we can talk about concepcion. I want to start with that. Another correction. Matt introduced it as if Wes and I were going to give the defense perspective. Well, that's just wrong. I'm already wearing two hats here. I don't intend to put on a third hat. So one of my hats is as a former U.S. District Judge for more than 2 decades. Another perspective is that I'm now one of those people that we've been talking about, the arbitrator. So I'm not taking on either the plaintiff side or the defendant side. I didn't do it as a judge. I'm not doing it as an arbitrator. So my firm will understand that although it is a defense side firm for sure, I'm not. I'm an arbitrator. That's what I do. Okay, with that beginning of corrections, let me tell you my view of the history. My view of the history, this is a classic case of be careful what you wish for. The defense bar fought against class actions for years. I was a member of the Civil Rules Advisory Committee that didn't write Rule 23, but revised it every few years. There were always tweaks going on to the Rule 23. As you know, I spent 7 years on that committee. We never had class actions off the agenda. So it was always being changed a bit, often at the initiation of the defense bar. So be careful what you wish for. The defense worked on these lawsuits. They got their win in Concepcion, in Italian colors, in Epic Systems. And now they're not so happy with how that all ended up. I wonder at times would they rather be right back in court dealing with the way it was structured to be, because it was structured to be efficient. And I handled many class actions, and indeed, I thought they were efficient. Courts developed the ideas of lead plaintiffs, they developed bellwether trials. Yes, most of them resulted in settlements. Yes, there was rarely, if ever, a trial of a class action. I was shocked to hear somebody say the attorney's fees weren't large enough. I don't know which of the two plaintiffs, oh, it was Mr. Gallo said that. I don't know what he's talking about, but you know, you're talking primarily in this webinar about consumer and employee, and I mostly did securities class actions in New York City. The fees were astronomical. They were in the thousands of dollars per hour when we worked backward with the lodestar. So I wasn't too concerned on either side. I thought plaintiffs' attorneys did very well. The defense reached their agreements. And of course, they bought global peace with those agreements. So it wasn't so bad for the defense either. I thought the court system worked fine. But let's talk about today. Now we're in the world of these mass arbitrations. And it is not unfair that the respondent has to pay per claimant. That's the way it was all structured. That it happens to come to $15 million, well, I guess somebody wasn't thinking through what was going to happen in big consumer or employee class actions. When you have thousands of claimants, there are plenty of class actions that don't have thousands. They have at most several hundred. That's a cat of a different color. I don't think that's the right phrase, but whatever. That's a different problem. But here, when you get these thousands and thousands, you're not happy with those fees. So I wanted to quickly segue into what CPR has thought of. CPR is a provider of neutral services. And they thought about the problem and they said, is there a way that we can help? And they got this idea of developing a protocol that would in some ways reflect what was done in court in terms of test cases, that they would randomly pick a number of cases. They would send them to individual arbitrations between 10 and 20 cases. They would use the results of those individual arbitrations to help a mediator try to work out a global settlement, which is always what happened in the securities fraud class actions that I handled. There was always a mediator who worked it all out. So the mediator would try, and if they failed, everybody could either proceed, the claimants could proceed individually in arbitration or court. That was the escape clause, that the individual could say, okay, I don't want to settle. I don't even like the settlement you reached. I want to go to court. Of course, it sounds better than it is because it's still an individual in court with potentially a $50 claim. So it sounded better than it is. But that protocol is out there. The problem is it's been litigated once rather unsuccessfully because it was a AAA case that the respondent tried to move to CPR. And the court wasn't having anything to do with that and said, no, your contract says AAA, that's what it is, so forget this protocol. So it wasn't really an attack on the protocol per se, but it didn't happen. So it's an untested protocol right now, and we'll see if any respondents, in fact, claimants too, we'll see if either side wants to give this a try. If not, you are where you are. So that's my initial spiel. Oops, you're muted. Matt?
Yes, Judge,
Oh,
given that AAA and JAMS are so overwhelmingly adopted as the arbitral form of choice, are you hearing that AAA is considering a mass arbitration protocol? And
I've heard it.
Like
I'm, by the way, I started with JAMS, now I'm AAA, so I went from one to the other, but I'm with AAA now, and I have heard talk of it, but I haven't seen any such thing. Maybe you all know, I don't know of it. The only one I know of is the CPR protocol, which is in your materials, the audience, if you want to take a look at it.
Thank you. Wes, let's swing back to you and unmute when you have a chance. Let's talk about, you get a call from a general counsel saying, I just got 125 things from AAA, and I called them and they said there's going to be boxes coming every day for the next 2 weeks. And it's going to be in the thousands. What do you do?
Well, I think that the first thing that you do in that situation is you read the arbitration agreement and you see what the arbitration agreement provides for and what's in there. As defense counsel, a lot of times you might be in that situation, you are rather sort of dealing with a situation that is predicated on an arbitration agreement that perhaps you did not assist in drafting. And so insofar as, so what myself and my colleagues at K&L Gates have been more focused on recently has been what sort of long-term solutions can we generate for prospective or current clients. And for long-term solutions, given the mounds of precedent interpreting the FAA and that precedent's bend toward the language of the arbitration agreement, that altering the arbitration agreement itself is a route that should be considered in a lot of instances. And in altering the arbitration agreement, there is a considerable amount of leeway for creativity there. So for example, the arbitration agreements at the center of a lot of the mass arbitrations today provide for a substantial majority of the filing fees to be paid by the respondent. So future agreements could include some sort of a sliding scale regarding cost sharing or a cap of the fee to be paid. Or somewhat counterintuitively, arbitration agreements that contain class action waivers and consumer and employment agreements could be altered to incorporate some collective action procedures such as bellwether trials, until a critical mass is reached, followed by mediation or conciliation, aided by some sort of a formulaic method to efficiently evaluate and value cases on a non-binding basis. And one institute that's been thinking a lot about that was just mentioned, the CPR, where they took a step to generate this protocol that is triggered anytime that more than 30 individual employment-related arbitration claims of a nearly identical nature have been filed with the CPR against the same respondent. And that incorporates ideas like early implementation of test cases that function a lot like bellwether cases in class actions that seeks to alleviate some of the expense of collective action and also provide more flexibility to the parties regarding the claims that are chosen as test cases. So for example, 10 cases, I believe the procedure is chosen by random assignment, and then each party can choose an additional 5 cases.
But on the additional 5 cases, could be contested, and an independent administrator would decide if there's a need for the additional cases. As luck would have it, I was appointed as that independent administrator, but there's no business yet.
So I'd love to jump back to Travis for a second. If Travis, let's do a little bit. We'll do about 10 minutes of war stories, and you're in this fight a lot. What have really been the highlights in your firm's handling of the mass arbitration filings and the litigation in trial court that's happened in relation to those filings?
Sure, thanks. I appreciate it. And I will respond to the question and make it responsive to wanting to jump in on a point that was just being discussed. So I will cover 2 things at the same time. With respect to the CPR protocol in particular, our firm litigated against the company DoorDash related to the CPR protocol. And I have immense respect for Judge Schindlin. I know she came on after the protocol was put into place. And so I'm going to say a lot about CPR, and in doing that, I'm going to say nothing at all about Judge Schindlin. So I want to make that clear.
Thank you.
But the war story is we litigated heavily the story of the development of that protocol. This was not an arbitration provider sitting around and independently thinking, how can we solve an issue that has come up? This was a respondent in a set of individual arbitrations approaching an organization to which it was and is a major donor, and colluding with it to generate a new protocol and to try to impose that on our clients while they were represented by us without communicating it through us, and in the middle of arbitration proceedings where they had already demanded arbitration, the company had refused to pay its fees, and a motion to compel was pending before Judge Alsup in federal court in the Northern District of California. Judge Alsup granted us discovery of CPR, including document discovery and a 30B6 deposition of the CEO. And what we learned was that the protocol were developed at DoorDash and Gibson Dunn's instigation, with their brainstorming and their ideas provided throughout the way in conference calls and meetings where red lines were exchanged, and that the draft protocol was ultimately made live and put on the website based on the timing that Gibson Dunn and its client DoorDash dictated. It would be great if Gibson Dunn were here today. They were slated to be on the panel with us and have a representative here, but we had an argument against them last week in the Ninth Circuit, and after that argument, they declined to come today. So that's a shame. But what I will say is that Judge Alsup had some words with their lawyers about the DoorDash efforts, and it was so obvious that they had gone so far beyond what anyone would consider to be a neutral forum where these claims would be heard, that their lawyers at the hearing declined even to try to hold our clients to the CPR protocol in the context of those current arbitrations that were then proceeding. So Judge Schindlin, of course, is entirely right. It wasn't ultimately litigated in that case because midstream counsel saw more than the writing on the wall and said, you know what, Your Honor, we'll stick with AAA for this clause. That's fine. But more broadly, I would say, we could probably have a whole panel on just the CPR protocol, and it is relatively untested. But you know, it was dictated or at least drafted by defense side interests to eliminate broad relief and to really eliminate widespread individual relief in the way that it forces a bellwether process, but with no requirement that the bellwether results be used in any mandatory way other than putting them into a mediation, where a defendant can continue to slow roll the dispute, which then rolls into successive mediations or potential court actions or potential arbitrations, depending on how the claimants or the parties might elect the road to go if the mediation is unsuccessful. That mediation, of course, though, is only happening after all these bellwethers have occurred and after almost all the claimants have had their claims told, to be sure, but have been waiting the entire time. They wouldn't be waiting in a class case where their claims...
They would be waiting in a class
So
case.
their claims
You
would be-
forget how long it takes to do class cert. You forget the motion
Of course,
practice
Judge.
on discovery. This would be shorter. This actually had a 6-month time limit for the test cases of no more than 6 months, and that's the toll. And then you're in mediation, which is a good thing, generally speaking. So I just have to, you're right, I had nothing to do with developing this thing at all. But I did want to debate you a little bit on those last points.
Well, we can agree on...
The tolling is shorter than court, and then you get to mediation, which is a good thing. Okay.
It is, and I would say only in response to that, Your Honor, that in a class case, though class cases can take longer, all of the class members' claims are being litigated simultaneously. And so whatever happens in the class is a development, positive or negative, and a binding development for everyone, which is not necessarily true in a bellwether.
Agreed, but I don't want the audience to think it's fast. They know better. It's not all that fast. It takes a long time to litigate some of these issues. And if you get a 23F on the class cert, you've got to go to the circuit. There's another 1.5 years. So let's be real.
Understood. And I guess, so Matt, my last comment on that would be just to say, I think Judge Schindlin is obviously, she's a good spokesperson for the protocol, and then she's the administrative arbitrator, and I think we'll have a chance to see the protocol tested. But in general, the view from our firm at least, and I think more broadly from this side of disputes, is that it's not a great look when an organization that is funded by donations that are almost exclusively from the defense side and that is governed by general counsel and defense lawyers and that has a history of being a commercial arbitration forum is now developing rules with a defense firm and a defendant in a then current dispute, and rolling those out to be put into consumer and employment arbitration agreements. So we will see how it goes, but all the discovery we took is public, and I hope it's helpful because I think in future cases there will be additional disputes as to.
I think your criticisms are fair. I think it is a commercial arbitration shop primarily. It really doesn't typically deal with employees and consumers, and maybe it's not one size fits all. So time will tell. But I just want to end by saying some of the ideas are good ideas. Bellwethers are around, whether it's class or arbitration. Mediation is around, whether it's class or arbitration. Something in me says maybe it's not so bad to give it a try. But I take your point, certainly about the development of the thing. I didn't know. I wish I had known.
So we did a war story and a mini debate, all in the same response.
Debate is lively on a panel.
We've got quite a few questions in the Q&A, and I'd like to have a few minutes at the end to get to them. But we've already had a little bit of talk about the future. Wes, you had a very intriguing prospect that consumer, large-scale employers and consumer service providers may be putting some nuance, frankly, putting in collective procedures of some sort in their agreements. I'd love to talk about two other things about the future, which is one, could this spark any change to the Federal Arbitration Act as we're looking towards what could be a much more consumer employee-friendly Congress and presidency next year? Wouldn't happen this year. And then the flip side of that coin is we're looking at a perhaps more defense-friendly Supreme Court, even more friendly than the EPIC systems court. How do we expect the Supreme Court to deal with the spirit of the arbitration and the Rule 23 issues if Travis's Ninth Circuit case or another case reaches the Supreme Court? So I'd like to throw that open to anybody who wants to chat about Congress or the Supreme Court in light of these issues.
I'll just throw in that, you know, if we wind up with a democratic government, there's a definite opportunity for a Class Action Fairness Act, which might radically change, you know, the way things are going in terms of forced arbitration. However, alluding back to what I said earlier, my personal belief and my personal business model is such that I think there are a lot of cases that are going to remain handled by, you know, mass joinder, permissive joinder, or arbitration. In other words, individually, because if you've got the procedures in place to handle cases individually, a lot of cases are better handled that way. You can get better results for your clients.
Okay. Anybody have any thoughts about how the Supreme Court might deal with some of these issues the first time they reach them?
Well, I'll just say this is not a spirit of the contract Supreme Court, right? And if it becomes more conservative, it's even less so. So if you're, I don't think there's a way to harmonize the last 15 years of arbitration jurisprudence with arguments that procedures and individuals filing claims exactly in the manner prescribed by arbitration agreements somehow are violative of the spirit of what defendants were trying to get away with here. So although you may see some interesting results or lineups if that view, a more text and contract focused FAA view, holds, you know, you could very well and should very well see pro-plaintiff FAA decisions upholding the arbitration agreements when claimants are following them as they're written. And I think you'd have, you know, 5 or maybe 6 votes for an interpretation of the agreements going in that direction.
I would think you're right, except we haven't seen a lot of consistency in any of our branches of government lately. So I wouldn't bet on consistency as the reason that you're right. But I still think, nonetheless, you're probably right in your prognosis that the arbitration would be enforced, and would, because they favor arbitration so much that they can't sort of do it halfway. They have to do it as written.
Josh or Wes, any more cynical or idealistic view how the Supreme Court's going to handle this?
I don't know. I'm not going to predict how the Supreme Court or Congress is going to handle this, but I would say, just sort of following up on, you know, a bit of what Ray was saying and others in terms of just the class procedure versus what you have when you are in arbitration. I mean, from my perspective, if my clients are forced into arbitration based on a contract for an individual determinations, it just seems, you know, we're going to want to litigate in a way that is beneficial for that, given the contract that has been imposed. So for example, it's an opportunity not to have to deal with some of the class action procedures, like having to show predominance. You've got thousands, you know, of employees in an arbitration that may have been harmed in a variety of ways by the employer, but maybe not in quite the same or similar enough way that you would satisfy predominance under Rule 23b3. You can still litigate all of those claims individually or in a mass arbitration setting and not get to the merits of them, get to some of the problems that the employees as a whole might be encountering in the workplace, but without having to worry about meeting a strict or arguably strict predominance standard in federal court. So, you know, it is sort of like be careful what you wish for, or the flip side of not having the class action procedures is that perhaps, you know, in these arbitrations, we can get to the merits individually without necessarily having the exact same claim being litigated.
Yeah, but I have a question for you, for Josh, or for Ray, either one of you. I mean, can you really do individual cases for 3,000 clients at once? Do you have that kind of staff? I mean, in other words, the same technique that sort of the respondents are upset about having to pay the fees as if there are thousands of cases at once. If you really had to, could you litigate 3,000 cases at once, individually, one by one before arbitrators? Do you have that kind of manpower?
Well, it depends on the strength of the case.
What does that
I mean, in some ways, it depends on the strength of the case and ways in which filing the cases can be phased in a seriatim way.
You have to staff
But,
each case.
from a plaintiff's perspective, I think if we prevail on a certain percentage of cases, that if there's fee shifting, allows for us to support more cases as a whole. There's also co-counseling that can happen. And there are also a variety of, platforms that people are developing and using in order to help try to manage the process. So it's not easy. It's certainly not.
Let's get
process.
to.
I want to hear, did Ray want to say?
One that is, but
Oh.
class actions are not easy either.
No.
So,
I think Ray wanted to weigh in briefly. If he could,
I just want to basically agree with what Josh said. The bottom line is, one of our criteria is that there's a basis for fee shifting, and where there is, and where we're winning, we can associate or hire as many lawyers as we need. You got some, good trial lawyer that tries the first 10, and then there's a playbook. And a third year with a personality or an army of them can try the remaining cases. And if we're winning, 30, 40, 50, 60%, depending on what the economics of the case look like, that's enough to continue pushing forward. And presumably at some point, a defendant gets rational and says, look, you're winning half the time. It's a $10 claim. You get $5 a piece. Let's go home. And that's what's supposed to happen.
Well,
Sure,
just
yeah.
really quickly, I know Matt wants to do questions, but really quick point, the rules in place that companies already chose when they chose AAA, for example, provide for ways that do make it easier. For example, the availability of desk arbitrations in consumer cases. These are cases that are submitted on the papers. And as I was saying before, if they would be classes but for the class waiver, there are common issues of law and fact. And so you do obviously need to know things about each individual claimant. Did they buy the product? Did they rely upon the advertisement in question, if it's a false advertising case, for example? But the underlying things an arbitrator would need to know in a set of papers to spend a few hours and decide a consumer claim, those are things that once you've done a class action depth and level investigation, apply similarly to all of the individual claimants, in addition to the facts that are unique about each person. So there are some efficiencies even when you are bringing truly individual matters.
So we have about a dozen questions, and we don't have a dozen minutes even. We have about 3. We're given a few extra time. A key question that was asked is the ethical obligations of the plaintiff attorneys when they're bringing all these cases that are nominally individual cases. And I know that Josh, Travis, the question of whether you were even retained was brought against you by one of your defendants. How do we think about, very briefly, the ethical obligations of plaintiff attorneys in these mass cases?
Well, I'm happy to go quickly. We can both go really fast, but I'll say how we think about them is we think about them a great deal, and they're important and fundamental to our practice. This is not the first plaintiff side practice that involves representing a lot of individual people in similar claims that are not susceptible to class treatment. There are types of personal injury, medical device, and pharmaceutical claims as just one example where that phenomenon is present. And so there are a lot of things to know and do to be compliant with the ethical rules, but we take those very seriously. And we're certainly not in the business of claiming to represent people whom we do not actually represent. But that's, I guess, step one of thinking about the ethical issues is make sure your clients are who they say you are. But beyond that, there are issues that anyone practicing in this area would want to stay on top of, but they're not unique to individual arbitrations at all.
So with apologies to a lot of other people who ask questions, there's one that's really interesting from a technical perspective, which is, what if you have multiple law firms bringing mass arbitrations against the same defendant over the same thematic area, as in mass torts and other areas? You can have 10, 15, 20 law firms in class actions pursuing the same case, and you don't have an obvious sort of lead counsel designation mechanism or committee designation mechanism as you do in class actions and mass torts. So what do you do with that? And should, perhaps under a protocol, should one set of lawyers' arbitrations be tied up with another? Is there any thinking about the interplay of those issues with multiple plaintiff counsel with different sets of pleadings?
I'm going to go with no.
Oh, go ahead. You go ahead.
No, that it hasn't been
I'm
solved
just going to
yet,
say
or it
no.
hasn't-
Listen, when you want to be in court and do it that way, great. Let's throw that out and go back to a class action to the extent appropriate. But I mean, if we're going to be in arbitration, my cases are my cases, Travis's are his, and we both want to do our cases our way. And all of our plaintiffs have an equal right to proceed at the same pace at the same time. And if the defendant doesn't want to do that, then they maybe shouldn't force an arbitration clause.
So, Your
Yeah,
Honor,
I would just add to that. It's
Yeah.
kind of up to the plaintiffs and their counsel whether they want to do it together or do it separately. And
That's what I would have said. If they can form a plaintiff steering committee the way they do in court, fine. And if they don't want to, that's their choice.
okay, let's
Wes,
see.
would the defense object to that? If we started coordinating, I imagine I can hear the cries and protests already.
I think that it would depend on the specific case and your specific client. I mean, there are already non-class action procedures similar to that in civil litigation. For example, in MDL, where you put everything before a pretrial judge and then you try it all separately. That again could be a type of procedure that could be implemented into an arbitration agreement where you are thinking creatively, or it could be something that could be, again, as was mentioned, just reached as between the parties in terms of sort of, reaching across the aisle to discuss the procedure there. So it's something where, again, I think that it would depend on the particular case and your particular client, but there are, numerous examples of defendants seeking MDL treatment for pretrial purposes in order to efficiently manage the pretrial phases without, while still preserving individual trials.
Yeah, I would have to add, I was an MDL judge a lot of times, and I think actually the defense would not object, Ray. You thought they might. They might not, because it gives them somebody to talk to, somebody to work with, somebody to get involved with settlement. They have a communication line that's more direct than trying to deal with a bevy of different plaintiffs' counsel. So I'm not sure there would be an objection on their side. It would add some efficiency.
I just said that because it sounded antithetical to the whole jurisprudence of individual arbitration.
No, I understand. Of course it is. Of course it is. But common sense begins to prevail on both sides. They want their 14,000 claimants to recover, and the respondent in turn wants to buy full piece. By the way, we were just granted 10 minutes extra, so we're not out of time.
Yeah, we are.
We must be popular.
That common sense prevails.
I guess so.
That common sense prevails on both sides has not been our experience. I would just say.
Well, not yet. It's new.
Perhaps.
Give it time.
But I think the reason that I would go with Ray's response, at least as an instinctive initial matter, is because most defendants in their class waivers also wrote out the possibility of consolidated, joined, group, coordinated, linked, and any other synonym you can think of proceedings, because they didn't want any of these things. And so you can understand, one can understand suspicion from this side of the bar. If all of a sudden a defendant now thinks coordination is a great idea, my view would be, too late, and you'll use that argument against us falsely when you say that our individual claims are somehow joined just because people are represented by the same firm. And so we have no need or reason to now give someone the convenience of a device that they shunned when they were forcing our clients to file individual claims.
Yeah, unless you decide it's good for you.
Unless both sides decide they have something to be.
That's correct. That's correct.
So, question for you, and we've been granted for the audience. We have 7 more minutes with generosity of our sponsors here. A question that's probably meant for someone who went to a better law school than mine, or went to one more recently than I did. Does anyone have any experience in the impact of these issues on collateral estoppel? Is that if that's an exciting question for someone, please answer it.
You mean in arbitration? Is there
Yes.
such a concept in arbitration? So if one arbitration on the legal issue is decided in a certain way, is that collateral estoppel to another individual arbitration? That's the question?
I think so. And
I don't think so.
In
That
California,
I don't think so, but if
California, the
anybody
answer
knows
is no.
otherwise.
In California, the answer is no.
Right.
one of the reasons we try and get something, anything into court, because if we can get, I have a case that I've got, an unbelievable amount of work into that's huge if it goes anywhere, where if I can just get one district judge to hear the defense's motion to dismiss, then I'll give cover to every arbitrator who might possibly rule in my favor. But otherwise, I can lose consumer arbitration after consumer arbitration because it's just a little too interesting an argument, although I think it's clearly right. So the answer is no, I wish. Maybe that could change, but nobody's going to give private arbitrators power to make law.
Correct.
What's the effect of, and that holds true even if you file the award of the arbitrator in court for enforcement.
Right.
That doesn't, all that does is just say that the adverse party has to comply with the award.
But the other thing it does is it makes a confidential process public. You can get a hold of that arbitration in the filing on the motion to confirm, which is always very interesting. The whole opinion is there.
So another question about industries. What are the industries that seem most susceptible to arbitration, mass arbitrations being filed?
Well, I get maybe the way to answer
any
that
industry with arbitration agreements.
Maybe the way to answer that is to say a slightly different thing in response, which is where are places that would frequently have been susceptible to class treatment, but where an arbitration agreement is possible and has been or can be put into effect. And then, simultaneously, if you're thinking about it from a plaintiff's perspective, perhaps what are other types of cases that might not have been as clearly able to be treated in a class, but where still there is an arbitration clause? Are those as interesting in terms of a firm representing a large number of individual people as a situation that very plainly would be a class, but for the waiver?
Travis, you want to consider collective actions too, because in addition to class, we had these huge collective FLSA actions, we had collective labor employee actions, so both class and collective, would be. But I'm not the one to answer the industry question.
Josh had a perfect scenario like that where he had something like 12,000 opt-ins to a collective action and then got compelled to arbitration. Maybe a mistake by the defense because he had 12,000 people who'd already said they wanted to participate, and a whole lot of them, several thousand, signed up for his arbitrations form.
Right.
And if it's the case we're thinking of, the defendant filed for bankruptcy, and in full disclosure, our firm's restructuring side acted for the creditors in that bankruptcy. And in the first papers that were filed in the bankruptcy court was a motion by the debtors to have the bankruptcy court unilaterally certify the entire FLSA collective as a class for bankruptcy claim purposes, even though there had been a decision by the district judge in California that a class waiver was enforceable. So they waived the benefit of their own district court decision in bankruptcy court. And Josh and I were talking about that at the time, and we're like, well, what are we supposed to do? We lost this issue in district court, or they lost this issue in district court, and the defendants are ignoring that, but it's probably to our benefit. So I think we filed a kind of weasel worded reservation, which said, we take note this is happening and we don't agree or disagree or something like that. And that was a very successful resolution in the end of the day, albeit by the low bar of bankruptcy cases. So we are out of time. We have 2 minutes left. Anybody on the panel have any final remarks before we turn the mic back over to our hosts?
I just throw in two quick things. One is that the example you just gave is something that can happen, right? If somebody's really going to bring all the individual cases, as Judge Shenlin pointed out, the defense may decide suddenly that class action sounds good. I mean, we settled a $40 million case that way that we would never have certified. This is several years ago now. And the other thing I wanted to just throw in is, I talked earlier about thinking a little bit differently. I just want to emphasize that as lawyers, we're used to doing the same things the same ways. But if you think about what technology can actually do for you, you can actually master a piece of software and have it be you, the senior trial lawyer, and have what you want executed perfectly 24/7, 365. That's the future of consumer practice. And it's It's doable, but you have to think in new ways, open your mind a little bit to some new things. And I'm fascinated by the whole thing.
Okay, let's let that be the last word. I want to thank everyone in the audience for spending an hour and change with us, and thank the Beer Group and all the co-sponsors of this conference with Dundon Advisers for making it possible.
Thank you, Matt.
Thank you. Thank you.
Thanks, Matt.
Thanks, everybody.
Thanks, everybody.
Thanks.
Judge Shendlin, Matt,
Yeah.
Ray, Josh, Travis, and Wes, thank you for that discussion. We could have discussed mass arbitrations for hours. This is an important emerging trend, and that was a strong topic to conclude the first day of our 3-day conference. We will resume tomorrow at 11 a.m. Eastern Time, and you should have received an email from Zoom today, which contains your unique login code for tomorrow's program. If you didn't receive this email, you will need to register again on our website, classactionconference.com. Thank you for joining us today. We look forward to seeing you all tomorrow and Wednesday.